Hey, oh, folks. So I asked a question yesterday. Proctor, what you gonna do? And today we found out that, well, Proctor voluntarily institutionalized himself or put himself in a mental health facility in Florida, of all places, voluntarily making himself a Florida man. Now, the jokes write themselves. And folks, let's just watch what happened. Okay? And using the Young Jerks stream of this. So thanks, Young Jerks, for providing the live stream.
To the clerk and to counsel, the motion and the two affidavits, which are provisionally impounded per the court's order. Within hours, my client and his family members received harassing phone calls pertaining to information contained in those affidavits.
Oh no! Oh, you poor things! You were sent. What attorney here says? Oh, this is harassing. They are sending him and his vile wife, who tried to get people fired for covering this case. They are sending them Proctor's own words. Oh, the horror of being confronted. You poor things.
I think it's safe to assume that the clerk's office did not disseminate that information on a Sunday afternoon, Your Honor. I obviously can't connect any dots, and I don't intend to do so here. But that is why we are seeking.
But you try to insinuate that. Blame them, Your Honor, not my client. Blame them.
Impoundment. This is obviously a very public case. I don't need to tell anyone that. But I don't believe that our client's medical personal information, a non-party to this case, needs to be all over the internet when we're just seeking a new deposition date.
Your client made his choices. But I do agree, his medical information should not be out there. The specifics of it should not be out there. Now, the rumors are that he is in a mental health facility in Florida. And by the way, why Florida? Florida, of all places. Well, from there he can refuse and state medical reasons. And it's a whole apparatus in getting somebody out of a Florida mental health facility to another state. Remember Alec Murdoch? He put himself in a Florida rehab center of sorts. Now, he left voluntarily, but if he hadn't, it would have taken a lot of time getting him out of there. And I guess Proctor is doing the same type of tactic. Find a mental health care facility out of state. Because why use any of the Massachusetts ones? There are some excellent mental health facilities in Massachusetts. Why go to Florida? And the answer I just said, it will be harder to get him out of Florida.
Your Honor, if I may respond to the inference from Mr. Hamill about how whatever he filed on Sunday ends up on the internet, there is I categorically deny and
Attorney
reject
Seligson, he didn't point any fingers. He could have meant me. I don't know. So let's move on. All right.
Okay. Thank you, Judge.
All right. Thank you. So the next issue is the motion before the court. Before we get to that, I find that there's good cause to impound the material that's contained in the affidavits, and I'm going to impound them provisionally at this time for purposes of this hearing.
Yep.
So, Attorney Hamill, do you want to be heard on your,
Now, it's an easy choice for the judge. Yeah, impound it, because there's no need for us to actually have it.
motion relative to the deposition.
Your Honor, just briefly, and I'd like to address a few things that were noted in the response of Ms. Reed. Again, we're seeking very limited relief in nature, Your Honor. We're seeking a new deposition date. 99% of the time, I could pick up the phone and call opposing counsel, and this would be resolved without the need to involve Your Honor.
Well, this isn't your ordinary case. You have a lot of parties in this. A lot. And all have attorneys that have to have their schedules cleared. And everybody had their schedules cleared for today. And then Friday, 3-something p.m., you file this. Here's the thing. Proctor didn't just go there to Florida 3 p.m. He didn't go down there that morning. In order to get admitted into a Florida mental health care facility, you have to first apply for it. You have to have a consultation for it if you're going in voluntarily. And you have to have the money for it. So this... Now, of course, Proctor could have chosen not to tell his attorney and just spring this upon his attorney last minute. I hope, for this attorney's sake, that is the case, that he called him Friday at noon and said, yeah, I'm committing myself because I'm deranged, vile, racist bigot who tries to frame people. I need to institutionalize myself. I don't know if that is what he said to his attorney. I don't think he did. But that would have been the truth. But you just don't go down there. You plan for it. Meaning, he should have told. The moment he started planning, yeah, you need to postpone because I feel so frail right now that I can't. Now, in my personal opinion, now this correlates to the filing the Karen Reed team did the other day when we found out more about Trooper Proctor. But at the same time, I honestly don't think that Proctor ever will voluntarily seat himself for a deposition. This was just a good excuse for him to not. My personal guess, at least, is Proctor planned to go somewhere anyways and make excuses. Now, folks, if you think I'm wrong, tell me so in the comments. If you think I'm right, tell me that as well in the comments. If you want to have fun at Trooper Proctor's expense, do so in the comments, okay? Because this is just accountability. I do not feel sorry for him one bit. Not one bit. There are many, many people in society that actually needs a mental health facility, but they can't afford it, or they're not provided with it. So no, this vile human being being exposed does not, for me at least, say, oh, now we are going to feel sorry for you, Mr. Proctor. Because I sure as heck don't. Let's continue.
In the court. That's not the case here. Ms. Reed's opposition.
Attorney Himmel, hang on. I mean, normally you could, but normally it wouldn't be 4 or 5 days before the scheduled deposition. The information that you're relying upon would have been provided much sooner than that.
Understood, Your Honor. And I know Your Honor had a few specific questions in the order that was put out last week, including when we learned of that the circumstances of Mr. Proctor's unavailability late Thursday. We informed counsel of his unavailability.
Late Thursday. Okay. Yep, might be true. Well, it has to be true, because if it isn't, this attorney is in deep trouble. And I don't think he will risk his bar card for Trooper Proctor. Now, exactly how it happened, don't know, don't care.
First thing Friday. I fully agree that the timing is unfortunate there, Your Honor. Ms. Reed's opposition seems to suggest that we first reached out to our clients on Wednesday, June 3rd, about his deposition. That's false, and that's not in the affidavits. We communicated with our client about the deposition back in April, when we agreed to reschedule the deposition at Ms. Reed's counsel's request.
Yeah, but the rescheduling in April was... They started doing that a month before for the April deposition and rescheduled it for today. They made that over a month, I believe, over a month in advance. That's not the same as late Friday before the actual deposition.
Again, we intend to produce Mr. Proctor for his deposition, but given the circumstances set forth in the provisionally impounded affidavits, we need a new date, and we believe we have put good cause on this record to obtain a new date.
You state you'll produce him, but you don't give an indication in your filings when.
Oh.
Yes, Your Honor. As noted in the impounded materials, my client's situation is ongoing. We are in constant communication with him, and we will provide dates as soon as possible to counsel. I understand we are on Mr. Proctor is not a party to this case, but we understand that the court is on an accelerated discovery schedule with August, I believe, discovery deadline. We can get dates to counsel by the end of the week, if that would be satisfactory, and would be happy to provide a status report to the court on that once that's done.
Yeah, no.
Would you like to offer anything else, Attorney Hamill?
No, Your Honor. Beyond what's in our papers, we'll rest in our papers. Thank you.
Attorney Seligson.
Thank you, Your Honor. Obviously, we are opposed to the motion for protective order. This is a duly noticed deposition. The subpoena for the deposition went out in April. There was an agreed upon date of June 8th, which we have prepared for, we have strategically planned for, we've incurred costs. Now, 4 days before the deposition, suddenly there is a need to continue it. There is no, other than conclusory statements, which I understand the judge, you're going to impound, but other than conclusory statements, there's no evidence provided of what exactly is the reasoning for family commitments that may be impacting the ability to attend today, health issues that are causing the inability to attend today, to seek a continuance on the eve of such an important deposition after we have incurred so much time, effort, and expense, including travel. Attorney Jackson traveled from California here to conduct the deposition, and we planned around that, and strategically planned around that. And the schedule that Your Honor is keeping us to, this is highly prejudicial to my client. The reasoning is not sufficient. Mr. Proctor says in his affidavit that his attorneys had contacted him on June 3rd to discuss and prepare for his deposition. And then we learn on June 4th that they're not coming after we seek out simple list of attendees so that we can give it to the security desk. At no point from April until June 4th did we learn that there was any issue Was there any request for any continuance, any request for any accommodation? And we've prepared and incurred costs and expense getting to this point. And we're here today in strong opposition to the deposition being continued.
Attorney Seligson, you used the phrase strategically prepared for.
Yes,
And
Your Honor.
it raises a question in my mind relative to the new Bristol action that was filed last Thursday, I think.
Yes, Your Honor.
And Ms. Reed's attorneys were fully aware that Attorney Hamill's office was involved on behalf of Mr. Proctor, correct?
Yes, Your Honor. For the deposition in this case, yes.
Was notice of that intent to file the Bristol action given to Mr. Proctor's attorneys?
No, Your Honor. Firstly, I want to be respectful of the court's inquiry. I also want to be careful how I discuss our strategic attorney work product, attorney-client planning. When I say strategic, I mean sequencing of depositions. Nothing to do with the Massachusetts State Police complaint we filed. Those dates.
That's a separate case, but I do think it was planned to rattle Proctor before the deposition. But in retrospect, maybe they should have waited until the day of. Yeah, let's just say that.
There wasn't some kind of effort to impact the deposition with the filing of the complaint, if that's what the court is asking. Strategic, as I stated, was with respect to sequencing of depositions in the wrongful death case, which we have been talking about as a team for months. That's what I mean, Your Honor.
Okay, thank you. Anything else, Attorney Seligson?
Your Honor, what I'd like to do is ask the court to deny the motion. And if the court's inclined to grant the motion, we would ask that we be entitled to submit a petition for our fees and costs in having to redo the prep, redo the logistical planning. But again, we'd ask that the motion be denied and that Mr. Proctor arrive for his deposition today and that we conduct it as noticed.
Thank you. Attorney Proctor, do you want to be heard?
Your Honor, I just want to make it clear for the record that the plaintiffs intend to seek testimony from Mr. Proctor, but don't take a position as to whether that testimony is taken today or in the future.
Thank you.
Surprise, surprise.
Attorney Rose, do you want to be heard?
No, Your Honor, we take no position with regards to the motion.
Attorney Daly?
No, Your Honor. Thank you.
Okay. Thank you, everyone. We're going to take a short recess and I'll come back out. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Good, all right.
All right. Let's see here. Short recess.
Versus,
Oh,
Your Honor, we return to the record on the matter of O'Keefe versus CNC Hospitality LLC, and all counsel is present.
Thank you, Mr. Clerk. Mr. Clerk, I'm handing the clerk an endorsement on the motion before me, and I'm also going to read it into the record. For this case to proceed efficiently and for our system of justice to work, certain basic things have to happen. A subpoena needs to mean something. A lawyer's agreement needs to have some meaning. Lawyers need to communicate with their clients. Clients need to keep their attorneys informed.
yeah.
And when given an opportunity to provide support for a party's request, that party needs to avail themselves of the opportunity. Based on the record before me, there is insufficient information to support a delay in the deposition going forward. However, given the claims made in the filings over the weekend, I will delay making a final decision on the motion until 4 p.m. today to give Mr. Proctor's counsel the opportunity to supplement the record before me. The subpoena requiring Mr. Proctor to appear for deposition today is stayed for 24 hours. Further hearing will be held today at 4:15 p.m. by Zoom. I followed up with Attorney Seligson on his reference to strategically preparing for the deposition today because I read in the media of an appearance on the Today Show Friday morning where Ms. Reed said that her new civil lawsuit was always part of a plan that she has. And beside her were attorneys Alan Jackson and Charles Waters, who cast the case as a bid to expose institutional corruption in Massachusetts law enforcement and to hold someone accountable for the death of her boyfriend, Officer John O'Keefe. Although there is no duty on Ms. Reed's counsel to have informed Mr. Proctor's counsel of the intent to file the most recently filed Bristol County action, I think it is unreasonable to have not done so with a scheduled deposition pending and then to have filed such action 4 days before the scheduled deposition. The actions by counsel, Mr. Proctor's counsel seeking to continue the deposition at the last moment, and Ms. Reed's counsel filing its new action 4 days before the scheduled deposition with an obviously planned appearance on national television, brought to mind comment 4 to Rule 3.5 of the Massachusetts Rules of Professional Conduct, wherein it is stated, an advocate can present the cause, protect the record for subsequent review, and preserve professional integrity by patient firmness no less effectively than by theatrics. As St. Mary's University School of Law Assistant Professor David Bernardo noted years ago at a conference on professional responsibility, civility in the legal profession is generally defined as treating others, opposing counsel, the court, clients, and others with courtesy, dignity, and kindness. Thanks for appearing this morning. We'll see everyone at 4:15 this afternoon.
Yeah. And as of the time of the recording, there is some time before that follow-up Zoom. And I'm going to return to you with my commentary later. All right, folks. Thank you all for showing up. Thank you so much. And I will see you in a few hours in the next video. All right. Thank you. Bye-bye.